Hello, everyone. I'd like to welcome you to today's webinar. It is the first of a series of webinars and in-person presentations that the Department of Mines, Industry Regulation and Safety will be presenting over the next 4 or more weeks on the new work health and safety legislation. My name is Ivor Roberts. I'm an Executive Director within the Safety Regulation Group of the Department. It is my division that is overseeing the development and implementation of the new work health and safety legislation. I would like to commence the webinar with an acknowledgement to country. The Department of Mines, Industry Regulation and Safety acknowledges Aboriginal and Torres Strait Islander people as the traditional custodians of this land on which we deliver our services. We pay our respects to elders and leaders past, present and emerging. The purpose of our session today is to provide you with an update on the government's proposal for the work health and safety laws, and in particular, the work health and safety regulations. My colleague, Bill Mitchell, will deliver a 15-minute update on WHS laws. There will be a 45 minutes to ask questions thereafter. Bill Mitchell has a postgraduate qualification in business law and over 20 years' experience in policy development. He is the Work Health and Safety Project General Manager for the Department of Mines, Industry Regulation and Safety and has been involved with this project since its commencement in 2008. After Bill's presentation, you have the opportunity to have your questions on the work health and safety regulations answered. To ask a question, go to slido.com and use the code WHS1. We encourage you to ask questions on the work health and safety regulations. Please note that this webinar is being recorded and will be available on the WorkSafe website at a future date. Bill, over to you to give your presentation.
Thanks, Ivor. After a thorough examination by the WA Parliament, in November 2020, the Work Health and Safety Act received assent from the Governor and became publicly available. However, the Work Health and Safety Act cannot commence until the Work Health and Safety regulations are finalised. On 15 December last year, the Honourable Stephen Dawson MLC announced availability of exposure copies and the government's intention for the Work Health and Safety regulations to be published in the Government Gazette in March 2022. Originally, the Work Health and Safety laws were scheduled for commencement in January 2022. On 17 December, the Department of Mines, Industry Regulation and Safety published the exposure drafts of the Work Health and Safety regulations on its website. Minister Dawson also committed DMIR's officers to delivering information and update sessions about the Work Health and Safety laws during January 22 in the metropolitan and regional areas. DMIRS has 25 sessions scheduled. Some of these are webinars, which will provide those members of the community who are not able to attend in person with the opportunity to receive information about the Work Health and Safety laws and ask questions. The Work Health and Safety Act and accompanying regulations total over 1,500 pages, with 550 odd pages in the Work Health and Safety General Regulations. In the time available to us today, it is not practical to go through each of these Work Health and Safety. The government has provided you with the exposure copies to enable you as workplace participants to prepare for the commencement of the Work Health and Safety laws. Before discussing the Work Health and Safety regulations, I will just take this opportunity to briefly discuss some of the key entities involved in the Work Health and Safety Act. A person conducting a business or undertaking has a primary duty of care to ensure the health and safety of workers while they are at work in the business or undertaking, and others who may be affected by their carrying out of the work. This might include visitors. PCBUs include a sole trader, a partnership or a corporation, and of course it can extend to profit and not-for-profit. There are particular exclusions such as volunteer associations, employees, workers and officers. Individuals doing domestic work in and around the home are also not workers. Officers, the definition of officer refers to the Commonwealth Corporations Act 2001 and persons who make decisions that affect the whole or a substantial part of the business or undertaking. If you like, the officers are the controlling mind of the business or undertaking. In many organisations, officers are likely to be senior managers and directors. For the public sectors, officers are likely to be corporate executive members or those reporting to the Director General. It's important to know that having officer in your job title does not make you an officer under the work health and safety laws. A worker is anyone who carries out work for a PCBU. And this might include an employee, a subcontractor or a contractor, a student gaining work experience, and volunteers. As a worker, you must take reasonable care of yourself, take reasonable care not to do anything that would affect the health and safety of others at work, must follow any reasonable health and safety instructions from your PCBU, and cooperate with any reasonable policy or procedure issued by the PCBU. While the PCBU is the focus, it's also important to note there are particular duties in the Work Health and Safety Act for PCBUs that are involved in the manufacture, importation, supply, and installation of plant structures and substances. This slide graphically represents the structure of the Work Health and Safety laws. There are three sets of work health and safety regulations. The focus of this presentation is in relation to the Work Health and Safety General Regulations. The MERS officers will also be conducting seminars for mines and petroleum work health and safety regulations. The Work Health and Safety General Regulations apply to mining operations, but do not include mine-specific regulations. The mine-specific regulations contain the Work Health and Safety General Regulations and include Chapter 10 of the Mine Safety Regulations. Some of the general regulations also apply to Work Health and Safety PAGO regulations. This is a copy of the index from the Work Health and Safety Regulations, and it obviously lists the topics. Not all workplaces have to comply with all regulations. For example, many workplaces do not have and are unlikely to have asbestos. In these circumstances, there will be no need to comply with Chapter 8. Other regulations do have a general application. For example, Chapter 3 and its managing risks to health and safety applies generally to workplaces. The chapter also includes particular regulations in relation to remote or isolated work and protection from tobacco smoke. Major hazard facility regulations and the related schedules in the Model Work Health and Safety Regulations are not being used in WA. However, the government has committed to review of the Dangerous Goods Act within 2 years of the Work Health and Safety laws commencing. For those who might be involved in matters such as authorisations, licences and registrations, Schedule 2 of the Work Health and Safety Regulations prescribes 32 fees. Some of the fees correspond to those under the WHS Regulations and Act, and there are also some new fees and charges as well. The high-risk work licence requirements for boiler and residential requirements in the Model Work Health and Safety Regulations have been amended. The 500 kilowatt threshold for boilers and the requirement that high-risk work licence assessments be conducted in WA are consistent with the WHS regulations. The Work Health and Safety Regulations recognise that WA does not register engineers and requires that in certain circumstances, competent persons are eligible for professional engineer membership of Engineers Australia. So these amendments, for example, apply to major inspection of registered mobile cranes and tower cranes. In WA, each time a tower crane shifts location, it requires design and item registration, and this registration includes reference to the base. The Model Work Health and Safety Regulations specifically exclude the requirement for tower crane supporting structure or the foundation to be registered under the new location. The Work Health and Safety Regulations have been amended to remove that tower crane exclusion. The existing WHS regulations require that the main contractor for a construction site where 5 or more persons are likely to be working at the same time must ensure an OSH management plan is prepared before work commences. The model work health and safety regulations set the threshold at $250,000. The work health and safety general regulations have been amended to adopt the 5 or more persons threshold from the OSH regulations. The OSH regulations require that medical practitioners provide a copy of health monitoring reports to the regulator. The model work health and safety regulations place the duty on the PCBU. The work health and safety regulations have been amended for consistency with the OSH regulations. So there are some new parts for the work health and safety regulations as well. Requirements for tobacco smoke and fatigue management when driving a commercial vehicle are important features of the OSH regulations. These provisions are not in the model work health and safety regulations. However, they are in the work health and safety general regulations for Western Australia. In addition, the government has included a duty on PCBUs to prevent, so far as is reasonably practicable, exposure to second-hand tobacco smoke. Another new measure in relation to the work health and safety regulations has been audiometric testing. Audiometric testing is required where a worker is frequently required to use personal protective equipment to protect against the risks of hearing loss because the noise exceeds the exposure standard for noise. A 2-year transition period has been provided in order for compliance with this regulation. High-risk work licence applications are to be received no more than 60 days after the issue date of the statement of attainment. Unlike the OSH regulations, the work health and safety regulations do not provide authority for applications to be received after the 60 days have expired. High-risk work licences can be renewed up to 12 months after the expiry date. This is a change from the OSH regulations, where high-risk work licences can be renewed up to 2 years after the expiry date. Like the OSH regulations, a construction induction white card will be required before a person can carry out construction work. In addition, the training will be required for the holder of construction induction training card who has not done construction work in the last 2 years. The accepted practice has been that asbestos registers are not required for buildings constructed after 1990. The Work Health and Safety Regulation amend this, and the new threshold date is 31 December 2003. There is a 12-month transition period for this requirement, and it does not register is not required if no asbestos has been identified at the workplace and no asbestos is likely to be present at the workplace. The Work Health and Safety regulations also impose authorisation timelines on the regulator. These relate to authorisation decisions he might make. He might decide to refuse or grant an accreditation. There's 120 days notice he needs to provide, and then before suspending and cancelling an authorisation, he must provide 28 days written notice. Regulation 676 prescribes who may request an external review of the regulator's decision. For example, high-risk work licence accreditation, the applicant and the RTO that engages the accredited assessor can request a review of a decision by the regulator. Transition has been quite a topical issue. In general terms, like the Work Health and Safety Act, the Work Health and Safety regulations include measures that set out how arrangements under the existing workplace safety and health laws are intended to transition to the new system. All duties under the Work Health and Safety regulations that are the same or very similar to the previous duties under WA's existing workplace safety and health laws start on and from the date of commencement of the Work Health and Safety regulations. Specific duties under the Work Health and Safety regulations that are new or significantly modified compared with WA's existing workplace safety and health laws will generally have a 12-month transition period unless otherwise specified. Authorisations such as licences and registrations will be recognised by the new Work Health and Safety regime. Details about the transition are provided in Regulation 2, and the title of that regulation is Commencement, or in Part 11.4, starting at Regulation 705. Webinars in relation to authorisations, including asbestos, high-risk work licences, demolition and plant, will be conducted on the 1st and 4th of February. Details and booking options will be available on the DMIRS website in the next day or so. There are a number of ways you can be kept up to date by DMIRS in relation to the work health and safety laws, and you can see the details there. As I mentioned earlier, there will be other presentations in the regions and metropolitan area occurring through January. These will be face-to-face and webinars. If you require further information about the work health and safety laws, you're more than welcome to attend these sessions.